I was sitting 3 feet from my daughter-in-law, Renee, when I heard her tell a judge I could no longer be trusted with my own money. Her voice was calm and rehearsed, like she had practiced it in the mirror. She said I had missed payments, forgotten bills, and needed supervision, and the judge believed every word, because the petition asked for control of exactly one account, the smaller one, already $8,400 into overdraft. So I let her have it. Never assume the account someone begs a judge for is the one they should have wanted. My name is Patricia Coleman. I am 71 years old. And this is how being underestimated became the safest mistake my daughter-in-law ever made. If you're watching this from a courtroom hallway of your own, or you've ever had a family member talk about you like you weren't in the room, tell me where you're watching from tonight. I read every comment. The hearing room smelled like burnt coffee and old carpet, the kind of room built for people to wait in more than to be heard in. 12 chairs bolted to the floor in rows, a state seal peeling slightly at one corner behind the bench, and a clock that ran 4 minutes fast, which I only knew because I'd checked my watch against it 3 times in the first 10 minutes. A young attorney I'd never met, hired by Renee through some referral service, stood beside her shuffling papers he clearly hadn't finished reading on the drive over. Renee sat 2 seats down from me at the petitioner's table, in a gray blazer she'd bought specifically for this. I found out later, 3 days after she filed. She kept her hands folded on top of a manila folder like she was posing for a photograph of someone being reasonable, and every so often, right before she said something she'd clearly rehearsed, she'd turn her wedding ring once around her finger. I'd noticed that habit at my own mailbox back in March, the first time she came by unannounced. By that morning in court, I'd counted it enough times to know it wasn't nerves. It was a tell, the same way a client's foot tapping under a table used to tell me exactly which line item they were hoping I wouldn't ask about. My son David sat behind us in the gallery, not at the table, because in the eyes of the court this wasn't his fight yet. It was Renee's petition. Her name was the one on the paperwork asking a judge to decide whether I still got to run my own life. Mrs. Coleman has shown a pattern of forgetfulness, Renee said, reading from a page of notes. Missed the property tax escrow payment in April. Let her homeowner's insurance lapse for 11 days in May. At 71, living alone since my father-in-law passed 3 years ago, we're simply asking the court for a limited, temporary safeguard while the family assesses the situation properly. I did not correct her out loud. I had spent 34 years as a CPA reading documents before I signed them, and I had learned a long time ago that the person who speaks first and fastest in a room like this is usually the one who hasn't finished thinking a thing all the way through. The petition asked for exactly one thing: temporary limited authority over a checking account ending in 4471. Not my retirement savings, sitting untouched at $120,000. Not the house paid off 11 years ago. Just that one account, the smallest one I had, the one I use for contractors, the lawn service, the odd household expense. I already knew, sitting there in that bolted-down chair, exactly why she'd picked it, and exactly what was sitting inside it, quietly waiting for whoever took the wheel next. Mrs. Coleman, Judge Hollis said, looking at me directly for the first time that morning, is there anything you'd like to say before I rule on the temporary order? Everyone in that room expected me to defend myself. Diane had told me I could if I wanted to. I looked at Renee, still turning that ring, and I looked at David, pale in the gallery, and I said only, "No, Your Honor. I trust the process." I watched something flicker across Renee's face that I would only understand weeks later. She had expected a fight. A fight would have looked, to a judge who didn't know either of us, exactly like the pattern she'd described. The judge, a tired-looking man who I suspect had heard 4 other petitions before lunch that day, granted the temporary order. 30 days, subject to a mandatory review hearing. Renee exhaled the way people exhale when they've just closed on a house. Outside the courthouse, Diane caught my elbow before I reached my car. "You didn't even blink in there," she said. "I need you to tell me you understand what we just agreed to. For 30 days, she has real authority over that account. If something goes wrong with it, that's on the record as her responsibility, not yours. That cuts both ways, Pat." "I'm counting on it cutting exactly one way," I told her. Diane studied me for a second the way she used to study opposing counsel before a deposition. "You already know what's sitting in that account, don't you? You've known for weeks." "I've known since the day she asked me for the number," I said. "I just needed a court to hand her the keys instead of me. I want to tell you how we got to that room, but not the way you'd expect, because I did not spend the 30 days that followed panicking. I spent them waiting, the way I used to wait for a client's second quarter numbers to come in before I told them what I already suspected. 5 weeks before that hearing, none of this existed yet. I had a fall in my driveway in early spring, nothing dramatic, a wet patch of pavement and a bruised hip that kept me on a cane for about 10 days. Renee showed up the next afternoon with a casserole dish still warm through the oven mitts. And for the first stretch of it, I want to be fair, she was genuinely useful. She drove me to 2 physical therapy appointments that week when my own car sat in the driveway with a hip I couldn't trust on the pedals. She sat with me in the waiting room both times, reading a paperback, not once making me feel like a burden. I remember thinking, watching her flip pages in that plastic chair, that David had done well for himself. "I don't want you to have to think about the boring stuff anymore, Pat," she said, standing in my kitchen with my mail already sorted into 3 neat piles on the counter. "Bills, catalogs, everything else. You focus on healing. I'll handle the bills for a while. It's the least I can do." "That's generous of you," I told her, and I meant it at the time. I had no reason yet not to. "It's nothing," she said. "Which account do you use for the household stuff, the contractors and all that?" "I'll just keep an eye on that one so it doesn't slip through the cracks while you're on your feet again." I gave her the number for account 4471 without a second thought. Felt like a small thing to hand over. In hindsight, it was the only thing she ever actually asked for by name out of everything I owned. For about 11 days, her help behaved exactly like help. Then my insurance agent, a clipped, efficient young man named Kyle who has never once called me with good news, phoned to tell me my homeowner's policy had lapsed for non-payment. "That can't be right," I told him. "That's been on autopay for 9 years." "It was," he said. "The payment method changed about 3 weeks ago. New account on file. It bounced twice. I still keep a paper ledger, an old habit from the firm that nobody under 60 understands anymore, where I write down every recurring payment by hand once a year just to make sure nothing's drifted." I pulled it out that evening and matched dates. 3 payments had been quietly redirected off my main account and onto account 4471 in the same week Renee started sorting my mail. The property tax escrow, my Medicare supplement premium, and the homeowner's insurance. She had moved them. She had never funded the account to actually cover them. I did not confront her. Confronting her felt like handing her a chance to explain it away before I understood what it actually was. Instead, I called Mr. Foster at Third Colonial Bank, who has managed my accounts personally for over a decade, longer than Renee has been in this family, and asked him to start mailing me paper statements instead of routing everything through the shared online access she now had a view of. "Everything all right, Mrs. Coleman?" he asked. He's known me long enough to hear when a request isn't really about paper. "Just old-fashioned," I told him. "Humor me." The statement arrived 4 days later. Account 4471 was already $2,100 into overdraft, quietly accruing fees at $35 a pop. Renee had not said one word to me about any of it. Here is the part one want you to sit with for a second because it's the part that changed how I thought about everything that came after. She wanted access to money. And out of everything I own, the savings, the house, 3 other accounts with real balances sitting in them, she picked the one that was already bleeding. 3 weeks into all this, my sister Barbara came for Sunday dinner along with David and Renee. The 4 of us around the same table Arthur and I bought secondhand in 1988. Renee brought up, gently at first, that maybe it was time to start thinking about options for me. A phrase she used twice, once over the roast and once again over coffee, and I noticed Barbara's eyebrows go up both times. What kind of options? Barbara asked her directly, the way only a younger sister can ask a question everyone else is too polite to. Just something with a little more support built in, Renee said, smiling at me like she was doing me a kindness by saying it in front of witnesses. Not assisted living, nothing dramatic. Just somewhere with eyes on things. I said very little that night. I have found in 71 years that the people building a case against you will often tell you exactly what they're planning weeks in advance, if you're patient enough to let them keep talking. Barbara called me the next morning. Pat, what was that about? You've never missed a beat in your life. I know, I told her. I'm starting to think somebody wants me to look like I have. Renee called 2 days after that dinner, her voice light, almost casual. I found a wonderful doctor, Pat, just for a routine checkup, nothing serious, purely preventative at our age. Well, your age, I mean. Would you be willing to go, just to put everyone's mind at ease? If my own doctor thinks I need a referral, I'll ask him myself, I said. But thank you for thinking of me. She didn't push back, not that day. I found out 3 weeks later from the invoice exactly which doctor she'd meant, and exactly whose mind she'd actually been trying to ease. 3 weeks after the casserole, an envelope arrived at my house addressed to me, but clearly never meant to actually stay there. I almost tossed it in with the catalogs. It was an invoice printed on plain letterhead from a Dr. Elaine Marsh, initial consultation, capacity evaluation, paid in full. The card on file ended in the same 4 digits as Renee's. I read it twice at my own kitchen table, standing up, still wearing my coat. I have never met Dr. Marsh. There had been no evaluation with me present, no phone call, no 40 minutes of my time given to anyone by that name. Just an invoice dated 10 days earlier, sitting in my hands like a receipt for something done to me without my knowledge, in a room I'd never been in. That was the moment this stopped being about money and started being about my mind, and whether anyone was going to let me keep it. Before I did anything else, I called Howard Pruitt, a retired partner from my old firm who I still have lunch with twice a year, purely because I needed to hear a number-minded person tell me I wasn't imagining a pattern that wasn't there. Walk me through it like it's a client file, Howard said, the way he used to say it across a conference table 30 years ago. I did. The casserole, the account number handed over, the redirected auto payments, the overdraft, the invoice from a doctor I'd never met. Howard was quiet for a moment. Pat, if a bookkeeper came to me with this exact timeline for a small business, I wouldn't call it forgetfulness. I'd call it a documented pattern of unauthorized access, and I'd tell the owner to get a lawyer within the week. That's what I thought, I said. I just needed someone besides me to say it out loud first. I drove to see Diane Kessler the next morning. Diane and I have been friends since our daughters were in the same Girl Scout troop 30 years ago, and she has practiced elder law for almost as long, first at a big downtown firm and now out of a converted house 2 blocks from the courthouse. I put the invoice on her desk beside my bank ledger and watched her expression change in real time, the particular stillness of a professional recognizing a shape she's seen before. Pat, she said slowly, I want you to understand what this usually is. a paid capacity letter, especially from a single consultation with no prior relationship, no records requested, paired with some financial confusion pointed to as supporting evidence, that's a setup. It's usually the opening move toward a guardianship petition, or something close enough to it that it doesn't matter what they call it on the cover page. She turned her monitor toward me and pulled up the state statute, reading the exact phrase a petition like that would likely lean on. Unable to manage financial resources without assistance. I sat there in her office and listened to a stranger's legal definition of me, written into law 20 years before my son ever met Renee, and felt something colder than anger settle into my chest. You could call David right now, Diane said. You could end this today with one phone call and a conversation at your kitchen table. I don't want to end it today, I told her. I want to end it completely. Then answer me honestly, she said, folding her hands the way she does when she's about to make me sit with something. Do you want to win quietly, Pat? Or do you want to win in a way she never ever forgets? I told her I wanted the paperwork to do the talking. I had spent 34 years trusting numbers over people who talked fast and smiled while they did it, and I was not about to change that now over my own daughter-in-law, in the one stretch of my life when I finally had the time to do it properly. 11 days later, a process server knocked on my door at 9 in the morning and handed me the petition itself, folded once in a plain envelope. In the matter of the temporary limited conservatorship of Patricia A. Coleman, a hearing date 11 days out, and there it was, printed in black and white in paragraph 4, the specific account she was requesting authority over. Account ending 4471. Not my savings. Not the house. The smallest, most damaged asset I had, because somewhere in her mind, that made it the easiest order to win fast, and the least likely for a judge to hesitate over. David called that same afternoon, and I could hear something crack in his voice that hadn't been there before. Mom, I didn't know she'd already filed anything. She told me she was just talking to a lawyer about options, in case things got harder for you. I didn't think it would be an actual petition, with your name on it like that. Did you read it before it went in? I asked him. There was a long pause. No, I believed him. That was almost worse than if I hadn't. I called Diane that same evening with the petition spread out on my kitchen table under the lamp. She's asking for the smallest account I have, I told her. The one already underwater. Why would anyone build a whole legal case around $8,000 in overdraft fees? Because she doesn't know it's underwater, Diane said slowly, and I could hear her turning the same idea over that I already had. She thinks she's asking for a foothold, a small, easy win to establish the pattern, then come back for more in 90 days. So we don't fight the foothold, I said. Pat. Diane's voice had a note of caution in it I rarely hear from her. You're talking about letting a court hand her authority over your money. I'm talking about letting her have exactly what she asked for, I said, and nothing she didn't. Diane was quiet for a long moment on the other end of the line. You've thought about this already, before you even called me tonight. I've thought about it since the invoice, I told her. I just needed to hear myself say it wasn't reckless before I did it. While Renee prepared her case, I built mine quietly, the same way I used to build audit files for small business owners who assumed nobody would ever look closely at their books. I scheduled a full evaluation with Dr. Alam, a geriatric specialist 2 towns over with no connection to either side of this family, and I drove to 3rd Colonial Bank to ask Mr. Foster for something in person, not over the phone. 12 years, I told him, sitting across from his desk the way I'd sat across from hundreds of desks just like it in my own career. Every statement, every account printed and bound in order. I don't want anything summarized. I want it exactly the way it happened. He didn't ask me why, not directly, though I could see him doing the arithmetic behind his glasses. That's going to be a thick folder, Mrs. Coleman. Good, I said. Thick folders are harder to argue with than thin ones. He had it ready for me in 8 days, bound in 3 sections by year, a sticky note on the front in his own handwriting that just said, "Called if you need anything else, day or night, Rick Foster." I have known a great many bankers in my life. I have not known many who still write notes like that. Dr. Alam's office took 90 minutes. She walked me through a memory recall exercise, a series of orientation questions, a written portion with a pencil that felt strange in my hand after so many years of typing, and then unhurried, a conversation about my daily routines that felt more like tea with a colleague than an exam. "You balance your own checkbook by hand," she said at one point, glancing at my ledger, which I'd brought along out of habit. "Most people your age, or frankly any age, stopped doing that years ago." "Old habits," I told her. "Good ones in this case," she said, and made a note. Near the end, she gave me a simple word problem, the kind I imagine she gives everyone, and asked me to work it through out loud. If I had a checking account with a starting balance, 3 scheduled withdrawals of different amounts on different days, and 1 deposit landing between the second and third withdrawal, what would the ending balance be, and would the account ever go negative along the way? I did the arithmetic in my head in about 10 seconds, the way I've done it 1,000 times over 34 years, and told her exactly which day it would dip into the red if the deposit came a day late. She smiled for the first time all appointment. Most of my patients ask me to repeat the numbers twice. You asked me to repeat nothing. The written report that followed was scored, dated, and entirely unremarkable, which is to say it described exactly what a 71-year-old woman with a sharp memory and a lifelong spreadsheet habit should look like on paper. 12 years of statements sat next to it on Diane's desk a week later, spotless and boring in the way I've always found genuinely satisfying, right up until the exact month Renee took over my mail, where the pattern broke like a hairline crack across a windshield. Diane wanted to file everything immediately, end the case before the hearing ever happened, put a stop to the whole thing with one motion. I asked her to wait. If you've ever had someone underestimate exactly how much you were paying attention while they smiled at you across a kitchen table, hit subscribe now. Because the next part of this is where 34 years of reading fine print finally pays for itself. The night before the hearing, I sat David down at my own kitchen table, the same table where Renee had once offered to handle the boring stuff for me over a casserole dish, the same table Barbara sat at the night Renee first floated the word options, and I laid out everything I had: the invoice, the account switch, the overdraft fees, Dr. Alam's evaluation, 12 years of statements and 5 weeks that didn't match them. He went pale somewhere around the invoice, and by the time I got to the bank statements, he was quiet in a way I hadn't heard from him since he was a teenager caught in a lie he knew I already had proof of. "Did she really think you wouldn't notice?" he finally asked, and that question hurt more than anything Renee herself had done up to that point, because it meant he already half knew, and had let it happen anyway out of some exhausted hope that it would resolve itself before he had to choose a side between his wife and his mother. "I need you to do one thing tomorrow," I told him. "Say nothing and watch." At the hearing, Renee testified almost word for word what she'd rehearsed at that kitchen table weeks earlier. The missed payments, the lapsed policy, her concern dressed up as procedure. Dr. Marsh's letter was entered into the record without objection from her own side. And when it was our turn, Diane did something that made the court reporter glance up from her keyboard for the first time all morning. She didn't fight the scope of the petition. She agreed on the record that a temporary limited order over account 4,471 only, pending a full 30-day review, sounded like a reasonable narrow accommodation. Judge Hollis granted it. 30 days, then a mandatory review hearing exactly as before. Renee left that courtroom the way people leave courtrooms when they believe they've won something. She squeezed David's hand in the parking lot, loud enough for me to hear over the sound of my own car door. See? That wasn't so bad. She barely fought it. She had no idea what she had just agreed to be legally responsible for. Here is what happens when you become responsible for an account you never actually bothered to look inside of. Within 2 weeks, Renee discovered the overdraft was now hers to clear under the exact authority she had gone to court to obtain. The property tax escrow came due first. If it bounced, my homeowner's insurance, the same policy she had already let lapse once back in May, would be at risk again, this time under her signature, not mine, with her name now the one attached to the account in every system that mattered. She and David covered $8,400 out of their own savings to keep the account from collapsing, 3 weeks before their own mortgage payment was due. I know this because Mr. Foster mentioned, carefully, professionally, that a large transfer had come in from an outside account belonging to a Renee and David Coleman. He didn't say anything else. He didn't have to. She never once called to ask me for help. I never once offered it. That was the agreement neither of us said out loud, the whole 30 days. Barbara called me twice that month, checking in the way she always does, half worry and half curiosity she'll never admit to. You sound awfully calm for someone who technically doesn't control her own checking account right now, she said the second time. I control the ones that matter, I told her. I just let her think she'd won the one that didn't. You are a genuinely frightening woman, Patricia, Barbara said, and I could hear her smiling when she said it. I mean that with love. I learned from the best, I said. 34 years of clients who thought their books were clean right up until the day I opened them. Some nights during that stretch I sat up later than I should have, reading through the state's guardianship statute myself, line by line, the same section Diane had shown me on her monitor weeks earlier. I wanted to understand, in my own words, exactly what standard a court would use to decide whether I still got to run my own life. I found a phrase near the bottom of one section that stayed with me. The court shall consider the least restrictive means necessary. Nobody in Renee's petition had ever once asked what the least restrictive option looked like. They had gone straight for a courtroom instead of a conversation, and I think that, more than anything else, told me everything I needed to know about which one of us had actually been paying attention to this family. The review hearing filled a different kind of room than the first one had. Ms. Whitfield, the court-appointed investigator assigned during the interim period, had done her own work in the meantime, entirely independent of either side, and she stood up first. I've reviewed 12 years of Mrs. Coleman's financial history, she told Judge Hollis, holding up the bound statements Mr. Foster had printed. It is, without exception, meticulous. The irregularities cited in the original petition, the lapsed insurance, the missed escrow payment, began the same week Mrs. Renee Coleman assumed control of her mother-in-law's mail and bill payments. I've also reviewed the independent evaluation from Dr. Alam, conducted at Mrs. Coleman's own request, which finds her fully competent to manage her own financial affairs, with no concerns noted. Renee's attorney tried, briefly, to argue that his client had acted in good faith, that concern for an aging relative wasn't a crime, that the overdraft itself proved exactly the kind of oversight the family had worried about in the first place. The overdraft began, Ms. Whitfield said, cutting cleanly through that argument before it could finish forming, the same week your client redirected 3 of Mrs. Coleman's auto payments without her knowledge or consent. I have the bank's own change of payment logs, time-stamped, if the court would like to review them. Ms. Whitfield turned to Renee next, still standing at the petitioner's table in the same gray blazer, now missing some of its confidence. Mrs. Coleman, when you redirected the 3 auto payments in question, did you notify your mother-in-law before or after making the change? I was going to tell her once everything was set up properly, Renee said. So after, Ms. Whitfield said. It wasn't really a question. Then she turned to Dr. Marsh's letter, still sitting in the file, and asked him directly, under oath, exactly how long his original evaluation had taken. Approximately 40 minutes, he said. A single consultation. And how many of Mrs. Coleman's prior medical or financial records did you review before that consultation? There was a pause long enough that I heard the clock on the wall, still 4 minutes fast, ticking through it. None, he admitted. I based the letter on the information provided to me by Mrs. Renee Coleman at the time of the appointment. I watched Renee's composure leave her face in real time, the exact way I imagine mine must have looked briefly, back at that very first hearing when I heard her call me forgetful in front of a stranger with a gavel. Judge Hollis looked at her directly over his glasses. Mrs. Coleman, you specifically requested temporary authority over one account, and one account only, out of your mother-in-law's several accounts. Can you explain to the court why that particular account, and not the others? She opened her mouth twice before anything came out, and what did come out wasn't an answer, just the beginning of one, trailing off into nothing that survived being said out loud in a room with a court reporter typing every word of it. The petition was dismissed with prejudice. My full financial authority was restored, without condition, without qualification, without so much as a follow-up review scheduled. Diane told me afterward, walking out to the parking lot, that I could pursue sanctions against Renee for the paid evaluation alone, that plenty of judges would have entertained it happily. I told her no. I hadn't done any of this to punish anyone. I'd done it so the truth would be the thing standing in that room when it mattered, not me raising my voice over anybody, defending my own mind like a woman on trial for the crime of getting older. David moved into his own apartment 2 weeks after that hearing, not because I asked him to, and not permanently as far as I know today. He told me, standing in my doorway with one duffel bag, that he needed to figure some things out, the same flat way you'd say it about a job or a diagnosis. You could have called me the day the invoice showed up, he said. Before any of it went to court. I would have listened. Would you have? I asked him. Or would you have told me I was overreacting, the same way you told yourself for 5 weeks? He didn't have an answer for that, standing in my doorway, and I didn't need one. I think what he actually meant, underneath the apartment and the duffel bag, was that he could no longer unsee what his own silence had allowed to happen at my kitchen table, week after week, while he told himself it would sort itself out on its own. Barbara still comes for Sunday dinner. My grandson Tyler, David and Renee's boy, still spends the occasional Saturday with me building model airplanes at that same kitchen table, because whatever happened between the adults in this family, I was never going to let it cost an 8-year-old his Saturdays. He doesn't know any of this yet. Someday, if he asks, I'll tell him the truth plainly. 6 months after the dismissal, Renee called me, for the first time since the review hearing. Her voice was smaller than I'd ever heard it. I don't expect you to forgive me, she said. I just wanted you to know David told me everything you actually had, all of it, and I understand now why you never said a word the whole time. I kept waiting for you to yell at me. You never did, and somehow that was worse. I didn't need to yell, I told her. I needed it to be true without me saying so. We are not close, Renee and I, not the way David probably still hopes we'll be someday. But she comes to Tyler's birthday now, and I come to his school concerts, and we sit in the same rows without incident, which at 71, with the years I have left, I have decided counts as enough. I still keep the paper ledger. I still balance it by hand once a year, the same week every January, sitting at that kitchen table with a cup of tea going cold beside me. It isn't about the numbers anymore, not really. It's about the discipline of looking closely at something before anyone else gets to tell me what it says. People ask me sometimes if I'm angry at Renee. I'm not anymore, or at least not in the way they expect. I think about her sometimes, turning her wedding ring the way she always did right before she said something she'd rehearsed, and I feel something closer to tired than angry. She spent 5 weeks building a case against my mind, and never once checked the one thing a person in her position should have checked first, which account she was actually asking a judge for. Arthur used to say that the truest thing about a marriage or a family wasn't what people said out loud at the dinner table. It was what they wrote down when they thought no one else would ever read it. He kept a ledger of his own for 40 years, half sentiment and half stubbornness, and I think some part of me kept mine the same way, long after the firm stopped needing it from me, because I already understood something Renee never bothered to learn about this family. The paper always outlasts the performance. If tonight's story reminded you that quiet and slow isn't the same as weak, tell me in the comments what you would have done differently sitting at that table in my place. And if you believe evidence beats volume every single time, subscribe, because the next story is about a woman who waited even longer than I did, and got even more for it.